Muy bien. Y con este llamado a luchar por un acceso pleno a la justicia universal, con respeto a los derechos humanos, se da por inaugurado nuestro primer foro internacional, La innovación en la justicia. A continuación, me resulta muy placentero informarles que se llevará a cabo la conferencia magistral de Netzai Sandoval Ballesteros, titular del Instituto Federal de la Defensoría Pública de México. Y quien va a presentar a Netzai es Cristel Rosales, investigadora senior de justicia del programa de justicia de México Evalúa. Déjenme contarles un poco más de Cristel. Ella es investigadora, como digo, de este programa y tiene experiencia en derechos humanos, justicia transicional y transparencia. Ha colaborado en el sector público, academia, organismos internacionales y sociedad civil, desarrollando metodologías de evaluación, investigación aplicada e implementación de políticas públicas. Así que con esta muy promisoria conferencia magistral, los dejo con Cristel Rosales. Muchas gracias.
Perfecto.
Hola, buenos días, buenas tardes a todas y a todos los que nos acompañan. La verdad es que es un gran placer iniciar esta conversación sobre innovación en la justicia y empezamos hablando sobre un tema sumamente importante.
Begin with a very important topic regarding rights, and that is defense. Defense is integrated by lawyers, men and women, who are defenders per se. These lawyers are the legal representatives of those who are charged with a crime in order to provide legal consulting, guarantee appropriate defense, and the exercise of their rights. That is why it is of the utmost importance to begin talking about the problems and issues they face, what their main challenges are, and what are the solutions that are being implemented to deal with them. Today, we begin this talk with Netzai Sandoval Ballesteros. Netzai Sandoval is the director of the Federal Institute of Public Defenders since 2019, January. He is a lawyer by the National Autonomous University of Mexico and a professor of law at that same university, as well as a professor of law by the Complutense University in Madrid. He is an expert in international law for human rights.
De amparo en la Universidad Iberoamericana de la Ciudad de México.
The University of Mexico.
Bienvenido seas.
Welcome.
Bienvenidos sean todos.
To each and every one of you.
Hola, muy buenas tardes. Muchísimas gracias, Cristel, por la presentación y muchísimas gracias por la invitación a este importante evento. Me da mucho gusto compartir con todas y con todos ustedes esta mañana. Nos convocan a platicar sobre la innovación en temas de justicia. Nosotros desde la Defensoría Pública creemos que justo la innovación puede ser no solamente tecnológica, pero pues que tiene naturalmente un componente de renovación, de mejora del servicio para las personas.
And improvement in our services for those who need public defenders. And it is my opportunity to head this institution at the federal level. It's the largest law firm in the country, and it is the institution that have the most litigating lawyers in the country. And they are there to serve people who cannot afford to pay a lawyer. During this administration, as many of you know, the institution for the public defender depends on the federation of the nation. We have a new president in the federation, Minister or Justice Arturo Saldívar, who has a deep commitment to defending human rights. And he has asked us and proffered support here at the Public Defenders Institution to strengthen our services. I am going to show you a brief presentation on some of the changes that we have implemented. But before beginning, if you will give me just a second, before beginning, I would like to share with you some thoughts. The Federal Public Defender's Office has the mission of contrasting its criminal justice work, and we litigate in many different, but in criminal justice, we have the duty of offering appropriate defense for persons who are in the most vulnerable of situations, those who cannot pay for private services. And we must contrast our work with the office of the General Attorney of the nation. So this is what we have done through most of our work. We have tried to make valid the principle of our Constitution, principles enshrined in our Constitution, and we have implemented many changes at the Public Defender's Institution. We have driven litigation by our high command, the Office of the Attorney General. The Office of the Attorney General also has its highest officers litigating because they are public defenders and can be in charge of cases. This tool was not in place formally. It only had the defenders, the base of our structure, litigating. But the higher command, the senior officers were in admin positions. They were not actually litigating. We changed that. And now everybody at the institution can be involved in litigation because these are some of our most experienced lawyers who can handle extremely complex cases. We are also implementing changes in giving them sufficient time to study the cases, which translates into two concrete actions. One, all matters are taken by the same lawyers from beginning to end. We have the same defender. In the past, we had a different lawyer working with each phase of the case. And they had to learn from the back work of others and start from scratch pretty much each time. Now, in addition, the lawyers have time for study and preparation for each one of the hearings. For the initial hearing, they have a free day. It's not a rest day, it's a day for study. They have 3 days to prepare a mid-hearing, 5 days for a trial. And we are implementing other very important aspects, litigation, and legitimizing the public defense so that our lawyers can have access without having to proffer notices to the prison authorities. And we are also having new laws that allow the public defender to come in with their cell phone to represent a person who is being held already in prison. This was not the case in the past. They had to come in with a piece of paper and a pen to try to take notes and understand the facts, but they couldn't record or take photographs or anything. And we are working to make sure this is changing. These are some of the improvements that I wanted to share with you. And I think that they are of the utmost importance. Very well, let's now move in to my presentation where we are summarizing some of the changes and improvements that we have been able to implement in this less than 2 years that we have been I have been heading this institution. It's very important because there are new departments that didn't exist. For example, the Strategic Litigation for Human Rights Unit is a new creation that we have driven based on lines of work by Minister Saldivar. Justice Saldivar, who talked at the Supreme Court and said that we needed a unit for strategic litigation and human rights. In the same manner, we propose the creation of a technical secretariat to counter torture, cruel, and inhuman treatment. In Mexico, there has been a history of many problems with torture, and the rapporteur Juan Mendez came to our country and he indicated that there was a problem of torture in our country, systematic for self-blame, leading to self-blame. So we have a team of lawyers that counter this, and it's to denounce and prevent this type of problem. Let's move to the next slide. We have here the creation of the new departments in the states of the country. There were only 27 states that had a presence of the delegation of the Public Defender's Institution. In criminal matters, we can defend everybody, and we could do so even prior to the changes, but there was another major area of work. We also litigate in civil, mercantile, administrative, labor, fiscal aspects, and migration too. For people to be able to approach the Public Defender's Institution, for us to be able to have a social worker that determines if the person needs a free access to a lawyer or not, we had to have an office where people could come and contact the lawyers. In criminal matters, perhaps it's not that imperative because any process, whether it comes to the public defender or to the judge, they notify us, and we have lawyers present in all of the states where there is a criminal justice or a federal public defender. But in other aspects, it was imperative to have delegations or departments. And so this effort that Justice Sandoval has created, we've created the remaining 5 that were missing to have all 32 states included in this service. We are supposed to have one for each justice circuit, but for many years there were missing ones, and this has come full circle now. Here we can see some of the results of the defenders, and here we can see the new system of adversarial justice, criminal justice. In recent years, in 2018, 2019, and 2020, we have seen some improvements. Our results, initially, we've been able to improve them with favorable options to 49%. The first one, 44 to 53, and the Second Circuit maintained at 1/3 in favorable results for defense. The next slide. Here we can see the results in the traditional criminal justice system, the system that is on its way out in our country because it is more of a mixed system or tending to be more of an investigative criminal justice system, a traditional one, and has now been raised to 86%. What the chart says is we see a smaller number of cases. This is due to the fact that increasingly we have fewer matters in the traditional criminal justice system. And we have 35 to 42%, and this was maintained above 80%. Let's move to the next one, please. The results index in other subjects, such as the ability to litigate in other areas or fields. And this is interesting because in some defenders of the region or the country, they only litigate in criminal justice. This is true in Chile and in other places as well, where the defenders are the only ones in charge. We also are involved in other matters. In truth, there are multiple terms that we can work with regarding children, boys, girls, adolescents, and we assign lawyers that are specialized in minors. And here what we see is above 80%. Our lawyers have favorable solutions in the First Circuit in more than 80% of the cases. There are many, many matters that are of the utmost importance, and the public defender assigns lawyers to cases, and the cases become renowned. Let me tell you 2 of these very quickly, but we don't always know that these are the public defenders that were in charge of these matters. And I'll tell you a little bit more about it when we get to the next slide. What we can see here is the number of crimes that we are representing and what they are linked to. Here we can observe very clearly that there is a strong linkage to the federal fire, explosives, and weapons law, and we're talking about 80% of crimes related to this. That is drug trafficking, narco trafficking, and people bearing arms. I think this is indicative and deserves much thought. I would say that if we cross the border and say go to the United States, 56% of our criminal activities would no longer be considered such if we change the approach on how we judge these in our country. In many places around the world, crimes against health or narco or drug trafficking in some places is also regulated and legalized to a certain degree. What I think is in this data indicates, and I'd like to underscore this, is facing the criminal phenomenon in our country, not just at the public defender's office, but we're facing crime that is targeting the lowest of levels in society, drug traffickers, dealers, those who bear arms. But if you analyze this graph, we don't see money laundering here or operations with funds from illegal sources, and we can't see bank crime here, white-collar crime, and mechanisms for protection, criminal structures, and even with the participation of civil servants. That doesn't appear here. We're stopping people on roadblocks and on the streets and working in a surface manner regarding these criminal behaviors, and we're not countering and combating what lies behind the operation of the funds, money laundering, and more. We have not tackled that yet. There's another interesting situation. We defend people of foreign origin, not just Mexican. Anyone who is accused of a crime, a federal crime, and who cannot pay a lawyer can approach the services of a public defender's institution. So this chart is very important because it shows that in Mexico there is prejudice, and in many places around the world, regrettably, that has to do with migration, waves of migration. People think that migrants are dangerous. People think that they come to a country to commit crimes. In our case, we have migration, particularly from Central and South America. And most of the media disseminate an image of this migration as though it were a matter of criminality, as though they were coming here to commit crimes in our country. And this is utterly false. 45% of the cases, crime cases that we have defended are from the United States. I'm not saying that they have come here from the United States. I'm saying that they are of United States citizenship. Guatemala, which is very far with 15%, or Honduras with 11%. These other nationalities, which are the second and third place, are well down on the list. What we see is people who are coming into the country legally, because we don't request visas from citizens of the United States, and they come and commit crimes in Mexico. This makes sense because in the United States, and there's a series of problems because these are coming into our country from the north of the border. There's a stereotype because we hear talk about gangs and criminal groups that come from the South, because in truth, the hard facts do away with this type of myth or prejudice against migration. Most of the federal crimes come from those who come from the north of our country, not from the south of our country. The adversarial system is a restorative justice mechanism, and we have to go back to preparatory crimes and suspend the process.
Llegar al juicio.
That prevent us from getting to a trial, an actual trial. So this image is quite alarming. As you can see, the number of problems that we can see from through plea bargains don't even represent about 1% of actual finalized matters in penal laws, and this is of trouble because that means that the General Attorney's Office is not using a plea bargain in a massive way. So that means that they're not turning detainees into informants. They're not using this legal tool that already exists in the penal code so that a person can obtain a benefit, and they don't have to go through the actual legal system, but that they are committed to know of the process and to denounce others within the structure
Obviamente esto es un problema
of the
que
penal system. And of course, this is a problem that is not only present since 2018. This is a phenomenon that has occurred since the onset of the adversarial system. That means that our Attorney General's office is still thinking of providing results that translate in having a lot of people being in prison, but not in dismantling these criminal organizations. So let's go to the next image. Here we can see one of the main innovations that the Public Defender's Office has implemented. We created a group of experts. As I told you, we were very committed to the principle of equality of arms. The defensorship should have the same capabilities of the accusatory party in order to prove and to demonstrate the innocence of a person, or at least to combat the accusation per se, to question the evidence, the data, the information that is being offered by the prosecutor's office. And this didn't exist before because when we before we arrived, there was no area of experts. There were no experts. The public defenders would have to go beg to academia for them to provide free services and to provide them with an actual expert services system for trials. And in most institutions would actually say no because they have a lot of work that is focused mostly on research, forensic science, not in trying to prove facts with a judge. So it was up to us to create, with the support of Justice Saldivar, this department we call forensic science, and we hired 10 experts, and in 2020 we hired up to 30 specialists and forensic scientists who are more than capable of offering scientific evidence and to question the evidence offered by the other parties in terms of things that are very precise in genetics and social anthropology,
en fotografía, en toxicología, en química forense,
in forensics chemistry, in psychology, in medicine, in criminalistics, orthodontology. We have a very valuable team that has allowed us so that the defensorship is no longer just on the aspect of knowing just law. In order to have a true defense, you have to provide arguments for the facts. So here we will see that our institution has been improving in this logic of offering facts and data to the judge, because we have worked in having actual data per se. We've turned to our public defenders who, or for instance, or even our factotums who actually just used their time to only take notes and make copies and to print things out and put things in a file and file things in general. We have changed that because we're now litigating electronically, and we have changed the logic. We say we have implemented a policy that we call zero paper. So we're using electronic and digital technology. We have the amparo procedure, the habeas corpus online. We have different formats and forms for our judiciary office in digitized version. And because our lawyers are no longer functioning this logic of having files and paper here and there, that has translated into savings as well. And the defender's office has changed things and the way their lawyers work. And our factotums can actually go there and provide and have information per se. So some of their tasks include search of information, search of data, specific documents that could be of use to the judges, interviews, updating of maybe a map, or looking for cameras or photographs, things that you can get not only from public institutions, but from like maybe businesses and the neighboring areas even. So this has become an important task of the defender's office. We are implementing a sort of a research police for the defense. We can't call it that per se. It isn't. That's not its formal name, because the investigation police can actually do official research and official investigation, and they do what we call a summons. For instance, they can even intervene communications and jam communications and do things that we can't do. But it's not like we have an actual police department, but we do are trying to give them a more robust set of tasks in data search efforts, so that we can go and see the actual truth of a specific case. So this next image tells us of what we have created, which is a defense hotel, a defense phone line that has provided services now that we have the pandemic. It is a call center, but it is a call center that is being attended to by lawyers. It is a 24-hour service too, and it works on a yearly basis every single day. It is important because you can have an emergency and you might require a free legal services, especially in penal matters. But we can now provide services to a person that has been detained due to aspects of maybe migration that have to do with migration, or something of a like. So you can call us at any time of the day or night, and we will provide you with free services through this phone line. And if that is the case, we can assign you to a lawyer that can represent you legally. Now we'll go to the next image. We can see how we have improved our systems of attention. When we created this public defender's office, we interrupted this. We had a sort of a fragmented schedule because, for instance, where we had our meal times, we wouldn't attend to anybody. But now, because we have this new system, we can attend to anybody's needs at any time of the day. And we have created a an appointment system that has allowed us to provide people appointments in a specific date and time, so that people don't no longer have to wait for their services. And this has been very important to us because in just 1 year, we can talk about more than 25,000 appointments in which you have the people coming in time and you have the lawyer attending to their needs. And we no longer have to have these big, huge lines in which you had to wait for over 2 hours even. We have also encouraged our lawyers to visit the prisons and the detention centers, and we see a number of brigades and groups that have been detained over the past few years. And this is important because before, brigades would have to ask the penal authority so that our lawyers could come in. But now we just give them a notice 2 days in advance, for instance, and the penitentiary authorities have to allow our lawyers to go in. And when we have a brigade or a group, a big group, when we have our lawyers individually, they can go in there with without any type of notification in advance. But if they do that in groups, they have to, and this is important because the authorities in jails and prisons didn't like for us to come in these brigades without appropriate notifications. There were even instances in which we were not allowed to go in, but through two amparo procedures, we managed to have our managed to force the authorities in prisons to allow us to go in. This is a right that prisoners have, and we no longer have to ask for permission or provide maybe notice in very much advance, to the prison or jail that we're going to visit. This is something we call an instrumental litigious procedure in order to provide the rights to the actual people that have them. Well, no, carry on, please. So I'm leading up to my conclusions. An improvement that we've had over the past few years has to do with tele appointments, long distance appointments. You now can have video conferences through a dialogue that like the one we're having right now, through the internet, through encrypted platform where you can have feedback and you can have the physical conditions even of a person, and this implies a modernization of what we're doing. And I want to share with you that we're improving our translation capabilities. We have a multicultural country, and we only had translations for only 138 linguistic variants, and we have that for over 138 of those. And we are educating our lawyers with the INALI, which is the Indigenous Language Institute. We have the specialties that are undertaken by our lawyers. We have training for people with different capabilities for international law. So if you have any interest in studying these cases in the Q&A session, I can actually talk to you about the cases we've had over the years. And to conclude, you can see in the electronic signature that the Public Defender's Office has improved its litigating capabilities. We no longer do this through packaging, through paper, through files. Our promotions, our claims and suits go through digitalization process. We have actually saved a lot so that the defender's office can be better. And we actually went from over 3,000 signed copies of documents to over 40,000 in just this year through digitalization. There's so many things I would like to talk to you about, but as our organizers have asked, we have also we also must allow people to have a feedback and time for the Q&A session. Thank you, Netzai. It was a very interesting presentation. What you're doing from the Defender's Office is also very interesting. We are actually going against time, unfortunately. We are out of time, but I would like to at least you to field two of the questions that we have received from the audience. We, of course, got a few other ones, but we will share those with you later on. Now, the first question has to do with that reality that we have with the country. This country that is so heterogeneous, so different, and it has such a wide and ample geographic scope. And we have so many marginalized peoples who face different circumstances. So how can a public institution face in an operative manner the way in which you can provide services to these restricted areas in these populations and places that don't necessarily speak Spanish or have the conditions to, in a way, make use of their rights. And the second question is, well, that in the country we have seen from the past years actually a wave of legislative reforms that in a way attempt at increasing the punishing powers of the state. They have increased the catalog of crimes that are considered serious, and crimes that automatically mean that people would go to preemptive jail or prison. So how is it that you cope with this from your defender's office? In facing this policy of the state that is punitive in nature. This is something that is going to you're going to have to face directly, and we don't know if through this increase of the people without sentences that you have that are no longer free, what is the capability that the institute is going to face? Well, first off, the first question, how are we going to make sure that people can access justice through a public defender's office? Well, first off, it has to do with what I talked to you about using technology, using communication through the internet, in the pandemic, well, these types of instruments were amazing, were fundamental. Like, for instance, the tele appointments, the long distance appointments, and the calls that we've had through the internet, so that our lawyers can continue to represent their clients. But it is also important to have our lawyers get out of the offices. Our lawyers now are going to where the people might need them. For instance, because we deal with migration issues, we go to their people's to the stations where they hold these people, the immigrants, where they are detained, or maybe the shelters where we have the immigrants. We have also established a few agreements and collaboration efforts with organizations, like, for instance, the Human Rights Commission or the NGOs that provide services to people who are facing migrational issues. It's not that they're waiting for us to come. We actually go to them, to the people that actually need. I mean, give you further examples of this, but I'm trying to synthesize or be as succinct as possible. Now, when it comes to the politics vision of our country, I can tell you that this is not just a problem in Mexico. I believe this is a worldwide problem. This punitive approach is easy to sell to the masses, and it provides in people a feeling that things are being done in terms of mitigating violence. However, it is just an easy way out. And what we're trying to litigate with, however, and I'm going to give you two concrete examples, we're trying to make our justice system more rational. That is, in terms of preemptive imprisonment. For instance, we have a sentence from that I believe is groundbreaking because it is important. We were represented the case of a woman that had an infant with her in jail. She was in preemptive jail, and the judges considered that there was nothing to be done for her because she had been accused, even though she had not yet been officially sentenced. She had been accused of committing a federal crime, a felony. So we asked the judge to look into what was going to be done to her. And the Constitution forces us to tells us that this type of unofficial imprisonment can only be sentenced before the trial, at the beginning of a trial. But at any point during the trial, this precautionary measure can be analyzed. That means so that the authority that issued it can check it again, can revise it. And there was no restriction. If you were to read the Constitution, there's no restriction. There's no place that tells you that precautionary measures cannot be stopped at any time during the due process. The Constitution tells us that actually there's a maximum duration of 2 years, but it also doesn't force us to reach these 2 years. So at any time in the due process, you can revise the precautionary measures. So what I asked the judge to do is to revise it, and the judge told us that there was no way this could happen, that it was completely absurd, and that it couldn't just happen, that he wasn't even going to go through the audience, through this next step of the trial, that there was no way in which this part of the process would actually happen, that it wouldn't be. So we actually had to initiate an amparo procedure, and we won that. And what federal justice tells us is that we can actually go and look into the precautionary measure. Of course, we can analyze the instances of, like maybe, for instance, preemptive incarceration. But what you do now is that you have a corpus of information in which that you can give to the judge, telling him, well, this person is not dangerous, this person represents no danger to herself or others, and this makes it so that we can rationalize our system. I can even tell you that the public defender's office is actually going into international instances. We are litigating with arbitrary measurements that allowed us to have a historic sentence. And this is something that was released on the media, but this is not something that people know. We actually stewarded. The United Nations task force established that Mexico had been abusing of unofficial incarceration, and that prolonged its time, and that there were cases that actually went over the legal frame of unofficial imprisonment. And this had to do with a human rights issue. The task force asked the Mexican state to reform its preemptive incarceration system, and this is something that our system is going to uh, come through with. Thank you, Said, for this intervention. I believe that we took so much from you, a lot of learning experiences and lessons and of course we will later on have this opportunity to continue the conversation. Thank you very much.